On November 25th, 2024, Orlando police responded to a Macy's after an employee was flagged for theft by loss prevention. She waived her rights, sat down, and talked. And what she said on camera may have sealed her own fate. So here is the question worth asking. When police read you your rights, do you actually have to answer? Now, let's break this down legally. The very first thing Officer Gonzalez did, before asking a single question about the alleged theft, was administer a full Miranda advisement under Miranda versus Arizona 384 U.S. 436 1966. Law enforcement is constitutionally required to advise any suspect in custody of their right to silence and their right to counsel before any interrogation begins. Every right was verbally confirmed on camera without pressure. That single act of procedural discipline laid the foundation for everything that followed. From there, the interview produced a full, detailed confession, and that raises the central legal test. Was it voluntary? Under Colorado versus Connelly, 479 U.S. 157 1986, the Supreme Court held that voluntariness is determined solely by the presence or absence of police coercion. Emotional distress on the part of the suspect, tears, fear, remorse, does not invalidate a confession. If the police did not coerce it, it stands. That ruling applies directly here, and it matters enormously for what comes next at trial. It is also worth noting that this was not a casual roadside conversation. It was a custodial interrogation, and the distinction is critical. Under Berkemer versus McCarty, 468 U.S. 420, 1984, Miranda protections attach the moment a person is in custody and subject to questioning. Officer Gonzalez correctly identified this as a custodial setting and acted accordingly. Had Miranda been skipped or administered incorrectly, the entire confession would have been at risk of suppression, regardless of how damning the content. Now, turning to the charges themselves. The subject admitted to taking cash from her register fewer than 10 times over 4 months, with individual amounts ranging from $60 to $400. Under Florida statutes section 812.014, theft of property valued between $750 and $20,000 constitutes grand theft, third degree, a felony carrying up to 5 years imprisonment and a $5,000 fine. Macy's placed the total at $2,100. The subject estimated under $1,000. At either figure, the statutory threshold is crossed. Grand theft applies. Beyond the theft charge, prosecutors also pursued a scheme to defraud under Florida statutes, section 817.034, the Florida Communications Fraud Act. This statute requires a systematic, ongoing course of conduct with intent to defraud. Not a single impulsive act, but a pattern. Multiple incidents across 4 months, using 2 distinct methods: register manipulation and deposit interception. Satisfy that element precisely. At the alleged loss amount, this is a third-degree felony, carrying an additional maximum of 5 years. Together, the 2 charges expose the subject to up to 10 years of potential imprisonment, which brings us back to the moment that determined everything. Under the Fifth Amendment, no person can be compelled to be a witness against themselves. Under Illinois versus Perkins 496, U.S. 292, 1990, a voluntary admission made with full awareness of one's circumstances carries the full weight of admissible evidence. She was informed of both rights. She waived both. Her on-camera confession covering method, frequency, amounts, and motive is almost certainly admissible in its entirety. One final dimension of this case is often overlooked entirely. Under Florida statutes, section 464.018, the Florida Board of Nursing holds authority to deny a license on the basis of a felony conviction involving moral turpitude or fraud. A conviction for either grand theft or scheme to defraud falls squarely within that provision. The subject stated she was studying to become a nurse. A felony record does not merely carry a sentence. It can close the door on an entire professional future. That is the full legal weight of what unfolded in this interview. Now, let's evaluate the two key parties in this footage. Officer Gonzalez receives an A-. His Miranda advisement was timed correctly, delivered clearly, and completed before a single investigative question was asked. Textbook compliance with established constitutional procedure. His interview technique was equally disciplined. Biographical baseline questions to build rapport, transparent disclosure of the likely outcome, and consistent professionalism throughout. The result was a clean, voluntary, prosecution-ready evidentiary record. The minor deduction reflects one refinement. The boundary between rapport building and formal interrogation was occasionally unclear, a distinction that matters. If a suppression argument ever reaches a judge, but that is a refinement, not a failure. This was exemplary police work. Mariana Hahn receives a B-. Her honesty was genuine, and cooperation of this kind may carry weight at sentencing. She made no false statements, confirmed she acted alone, and did not attempt to deflect responsibility. That speaks to character. But from a legal strategy standpoint, this was a costly choice. The Fifth Amendment right to silence is absolute. The right to counsel exists precisely for moments like this. Neither requires guilt to invoke, and invoking either carries no adverse inference at trial. One sentence, "I'd like to speak with an attorney," ends the interview immediately. She was told this. She chose differently. The grade reflects her conduct during the arrest itself, weighed against the decision to speak without legal protection, in a situation that now carries felony consequences. Before we close, this case leaves behind 3 lessons that go well beyond the incident itself. The second lesson concerns emotional state and legal exposure. Many people assume that being visibly distressed, crying, frightened, overwhelmed offers some form of protection in an interview. It does not. Under Colorado versus Connelly, emotional distress does not invalidate a confession. Only police coercion does. What you say while you are upset carries the exact same legal weight as what you say when you are calm. That is the standard the court applies, and it applies every time. The third lesson is the one most people never see coming. A criminal conviction does not end when the sentence does. For anyone working toward a licensed profession, nursing, medicine, law, education, a felony record can disqualify you from licensure entirely. Florida Statute Section 464.018 makes that explicit for nursing. The courtroom is only the first door that closes. Understanding the full reach of a conviction before deciding whether to speak may be the most important legal calculation of all. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching.